Hello and welcome back to Law Torn, the podcast that looks at what happens when family fights turn into legal battles. My name's Samara Dutton, a partner in the Trust and Estates Disputes team, and I'm here with my co-host Philippa, who is a partner in our family team. Hello, Philippa.
Hello, Samara.
How are you this week?
I'm very well.
That good.
Yes.
Good. So for our topic this week, we have had, excitingly, another sort of question come through to our email address, lawtorn@collierbristow.com. It's quite a long one, and I'm not going to read it all out, so I will just summarise the position. But it is from an individual, a woman, I believe, who is having quite a tough time. And her issues touch on sort of rights to property in unmarried relationships, but also with an edge of sort of intestacy and estates, etc. So it falls very squarely within our joint expertise. Yes. So well, I'm not pleased for her situation, but it's a good...
She's a tragic woman, really.
It is, yeah, it's not ideal. So basically the position is that she was in a relationship with her partner Daniel, she says, for just over 2 years. So some people would say not that long, but for her, it definitely felt as though they were building their life together and they had a long future ahead of them. He owned a flat when they met. And about 6 months into their relationship, she moved into that flat, but it remained in his sole name. So the legal title was in his sole name. She began contributing financially. So she was paying a regular amount to Daniel into his account, about £1,200 a month. And it was sort of, according to her, understood that went towards bills, towards mortgage, but it was not really discussed specifically what it was for. Also, she said that she's paid out about £40,000 towards a new kitchen for that property.
Nice kitchen.
I know. I'd quite like to come for lunch. So she had been, prior to that, she'd been living in a rented flat of her own, which she gave up. She said that when she moved in with Daniel, she began helping him with his small business, which was mainly run online. So she was sort of doing that from home and wasn't really paid anything specifically for that. And she says that, over the years they discussed and they referred to the flat as their home, that they had plans to sort of continue their life together. And that is what she assumed would happen. But then tragically, earlier this year, Daniel passed away suddenly, and he did so without a will in place, meaning that his estate passed under the intestacy rules. That means, well, in this case, it's his sister who has been given the right to administer the estate.
Do you think he's got parents? Because it would go...
It would normally go, yeah. I mean, obviously he had no children. Yes. So obviously his parents have also died, but we don't have that information here. But yeah, it's a sister of his who is administering the estate. The woman that's written to us doesn't know the sister very well. I don't think they were particularly close, the sister and Daniel. And so the sister is saying, well, no, the property's in his name and therefore belongs to the estate. Any money you've paid is for rent and or was up to you to improve the kitchen if you were living there. So has taken quite a stark position against our friend. And so she's basically, I'm just reading bits, but she's basically just looking for advice there. Is it really the case that she's got no rights at all, even though she's contributed financially? Is there anything that she can do? Is the law going to recognise sort of their relationship, their intentions, etc.?
Yeah.
I mean, as a starting point, she's very much in the sort of common law marriage myth that we've discussed previously, isn't she?
Yeah. I mean, definitely. And, there's nothing at the moment for her as a sort of widow in an unmarried relationship. But as we've discussed before, judges dance around and try and create some rights for people where it's clear to everyone that it's not a fair situation. I mean, hers is a shortish relationship.
Yeah.
And we don't know how old she is. I mean, she might be 60, she might be, 30, who knows?
Yeah, I suppose I'd assumed youngish.
Yeah.
Because there's no mention of children anywhere.
Yeah, yes, children would have been a good call from her.
I remember discussing with you said it helps to have children in this scenario.
Because they have a claim where the cohabitee doesn't, but
the law just won't, it's not going to recognise a relationship on its own, is it? There's always going to need to be something more.
Definitely not.
So outside of just sort of recognising unmarried couples' status in property rights, the avenue...
But change is on the way.
Ooh.
Well, I've been saying that for decades, but allegedly it really is now on the way. Anyway.
So we were going to cut to that later, but we will speak about it in more depth. But this is a consultation that's gone out recently, isn't it, about a fairer end to relationships or something along those lines.
Not necessarily death, but...
Yeah, okay. So what we have identified as potential solutions for her, but certainly not straightforward in either case, would be either a claim under what lawyers will refer to as TOLATA, which stands for Trusts of Land and Appointment of Trustees Act.
Administration.
I think it's appointment.
I think it's administration of estates.
One of us will be right. Let's see. We'll check and let you know next time. Oh, that's possible. Neither of us, right. But we'll just call it TOLATA for shorthand. And then the other potential avenue would be a claim under the 1975 Act, Inheritance and Provision for Family and Dependents. I think you couldn't have both. I think if you establish your claim to a right to the property, which would be the TOLATA claim, then it's unlikely that you would be able to establish also a claim under the 1975 Act, which goes to reasonable provision. So if you have...
But you'd start with TOLATA, wouldn't you? Because that establishes what you own, effectively.
Yeah. And then whether or not you need more provision from the estate as a result, which is what the 75 Act is concerned with. So TOLATA claims, they come up quite often for you in family contexts anyway.
Oh, yes. They're one of our go-to weapons where you've got an unmarried couple and a property.
Yeah. And the concept here is that where the legal title, so the one that's registered at Land Registry, does not reflect the actual ownership, although proving the actual ownership is...
And it's a, as we've said, it's a very sort of flexible approach that it's more trying to solve difficulties for vulnerable people as much as anything. So the law's quite flexible when it comes to things like that. Interestingly,
I was looking at the history of TOLATA for this. Did you know? Yeah.
No, I don't know anything about that.
Do you know? So prior to that, the law treated land basically as money. Yeah. So in a commercial context, it worked. So if there was a trust of land, it wasn't called. They would hold it on a trust for sale. Trustees would hold on a trust for sale. So the court assumed that it was an investment and any beneficiary's interest was in the money only. So the trustees could postpone sale or have a power to postpone sale. But ultimately what was going to happen was it was going to be sold and you'd get your money. There was no right to occupy the property and there was no real interest in the property itself other than for its economic value. And so the purpose of the Trust of Lands and Appointment of Trustees Act, it was 96? 96.
No, it was 96.
Was, as you say, to make things more flexible, recognising that people actually were attached to their homes rather than, to the money that their homes represented. And in order to bring in a bit more fairness and flexibility around ordering that people should have a right to occupy for a certain amount of time and perhaps they didn't want it sold, etc., etc. So it was already a movement away from the sort of quite rigid regime that just said, well, you're only interested in the cash, so effectively you can be compensated through money, to recognizing interest in the property itself. But so that's what we have now. And as you say, it is fairly flexible. It allows judges, I would probably say, because this is a theme of the difference between my type of claims in the civil courts and yours in the family courts, that your judges may be more willing to be more flexible.
Yeah, that's why if you're acting for the vulnerable person, you want to dash off to the civil court rather than the family. Sorry, the other way around. The other way around. If you're acting for the person who's fragile, you want the family judge to sort of, give them a hug, rather than something more.
But strictly speaking, so TOLATA says if you are a trustee or a beneficiary of a trust of land, then you may apply to the court basically for an order establishing what interest you have in that land. I mean, there's other things that you can apply for, but that's the one we're concerned with here. So she would apply and say, these are the reasons that I say that I've got an interest in this property. And what the court has to look for is a intention by the person who does have legal title to the property, the person who created the trust or the people that created the trust. So in this case, it would be her and Daniel. She's saying that they decided that they're sort of holding it for both of them. So you need to look at the intention. You have to look at the purpose for which the property is there, and also what you will need to establish, because you do need to sort of still show it's not just about the fairness of the situation. You need to show that you have acted to your detriment to some extent. Yeah. So for her, the things that are going to count in her favour that we're gleaning from what she's sent us are the financial contributions she's made, what she refers to as referring to it as their home.
His promise, effectively, I suppose, that this is their home.
Yeah, but promise is slightly different, isn't it? No. That potentially would be a different type of claim, although they're so closely intertwined. But a sort of promise and detrimental reliance would fall under proprietary estoppel, potentially. Whereas here, it's the intention. You must be able to demonstrate that it was intended that you would have an interest in the property, and that was why you acted to your detriment. It often is financial detriment, but it doesn't have to be. And in fact, I think she said, helped with his business or so. I mean, you can bring those types of things into these sorts of claims.
Yes, it's funny about the business, because I was thinking, how does she pay her £1,200 a month if all she's doing is helping him with his business? So she must have a job as well.
I was going to say, of course.
she's
yes, this is just what she's doing on top. So those are the things that will help her establish that. But equally, you can see the argument from the sister's point of view that, sorry, but legal title says it's my brother's. He bought it before he met you. There's nothing written to suggest that he meant for you ever to have an interest in it. It's not that unusual for someone to move in with a partner and pay some sort of amount towards that occupation of their property. Ultimately, I think it will come down to what she can show about the intention, and obviously not her intention, Daniel's intention. And that's where your evidence becomes crucial. Text messages, WhatsApp messages.
Cases are so expensive in a way, because, there's lots of tangential things like conversations with friends and...
Exactly. So you have to bring in all those witnesses that might have heard him mention, I want her to always live here, or those types of things. It's just digging through your relationship history to try and prove some kind of proprietary right. But in any case, that is one potential avenue of claim that she could make. But it will be highly, just dependent on the facts and what she can prove on the evidence other than what she says, because she needs objective evidence to confirm that, I think. And then the second...
So if that doesn't cut it. There's not enough there. Of course, we don't know what the property's worth. I mean, if it's worth £2 million, it's probably worth having a punt. If it's worth equity of 50,000, then it won't be.
No, well, that's a costs thing, isn't it?
Well, it's high risk litigation.
It's high risk litigation, and it would be in the civil courts. This isn't something you can bring in the family courts.
No.
So where sort of deadlines are a bit stricter and costs are a bit more of an issue, I believe. I feel like everything's a bit kinder in the family courts, isn't it? Sometimes.
Yes, up to a point.
So her second potential approach to ensuring she gets something is a claim under the inheritance, open brackets, provision for family and dependents, close brackets, 1975. I'm sure we've touched on this act before in the podcast, but perhaps if we haven't, we should.
We're going to go around these acts a lot, aren't
I know.
we?
These are the ones. These are our bread and butter. Yeah. 75 Act claim. In fact, to qualify for this, she could fall under one of two categories. One would be somebody living as though in a marriage. But to qualify under that category, you need to have been doing that for at least 2 years prior to the person passing away. Here, it's unclear whether that's the case. She says it's been a relationship of more than 2 years, but I think she didn't move in until after 6 months of going out with him. So I think we're somewhere on the cusp.
It's one of those, and this will come up if they do change the law, which is when have you moved in? So if you spend 6 nights a week somewhere, but you're still paying rent somewhere else, then how's that regarded?
You can have it. And where have you, where do you vote? Where are you registered on the electoral?
Your GP, that's one.
You get into those sort of evidential wars of who lives where. So yes, there's a huge amount of litigation that could go on just on that point. I think in this case, actually, if it is the case that she hasn't established an interest in the property, then the flip side of that is that he has been housing her, basically, although she's been paying it, but he's been providing the house. So arguably, she could fit under the category of people who have been maintained by the deceased. So let's assume that she gets through on one of the categories of claimants under the 1975 Act. Then what she would need to be establishing is that reasonable provision hadn't been made for her.
Which is easy.
Well, it is on an intestacy where you're not a family member. It isn't where somebody's left a will leaving you a tiny thing. Or just a small amount or something. But yeah, I think you could say, then you have to establish that you are someone that ought to have had some provision. But I suppose if you qualify as a category, then maybe that's implied.
I suppose you have to qualify under the 2 years. Is there any discretion about 2 years?
No.
Okay.
No.
So she would actually have to persuade the judge that it had been her home for 2 years living with Dan.
To come under that category. I'm not sure there's any benefit to coming under that category as opposed to just coming under somebody that was maintained, because the only sort of higher bar in terms of a category of claimant in 1975 Act is if you're a spouse or civil partner, and then you just get a bit more, basically. But here, I think it's cleaner to say, it would be nicer to say I lived with him for 2 years before, because then I think it is very clear that you need provision made for you. And the sort of the final category of claimants are always the sort of ones that you push everyone into. I would just chuck you in there. Did they take you out to lunch every now and then? You're going to see if we can put you into that last category. But if she is able to bring the claim and to establish that no provision is unreasonable given their relationship, and obviously she won't necessarily find that easy to do. I mean, it sounds as though sister is going to say, you had, as you said, a short relationship with my brother. He had many other relationships. He's moved in with people, but, there's any number of reasons why you shouldn't.
And of course, everyone's grief stricken. That's the other thing. So the sister will be presumably upset. Our woman is definitely upset, and no one thinks in a straightforward way when they're kind of caught up in that emotion.
And can upset the other people.
Yeah.
And sort of escalate positions as a result. What's the word?
So what she should do then is do a deal.
Probably the best way. I mean, definitely I wouldn't do anything practically for her. I would say don't be threatened by sister into just leaving because I think you need to stay in that property to try and begin discussions around it. If you disappear, then it will be sold before you know it, and it will be money, and then it's harder to trace, etc., etc. So I think initial advice would be stay where you are.
And they'd have to start possession proceedings to get rid of her, wouldn't they?
Yeah, if she stays in there, exactly, which is thoroughly unpleasant.
And takes a long time.
It would take a long time, but she would counter that possession claim with a claim to an interest in the property. So in a way, it sort of brings her claim up without her having to do the sort of running. So in sometimes tactically, that's a better thing to do. Yeah, so try and speak to sister. I think you're right. It's not settled. I
wonder if he died before or after the 1st of May.
Ooh. Well, hang on, because she's not. Oh, she is paying money. She's probably stopped paying money now.
Well, but is she a tenant or is she a partner?
Sorry, so the 1st of May, just to be clear, was because finally, after many years, the Renters' Rights Bill has come into force. And that has converted all tenancies into sort of periodic tenancies and makes it a lot harder. But I think if your claim is I have an interest in the property, you can't equally claim I'm a tenant.
No, she doesn't need to, though. She says, I've got an interest in the property. The sister says, no, you're not, you're a tenant.
The sister says, no, you're not, you're an excluded occupier, and I'm giving you notice to quit. She's not paying, either you're paying rent. Oh, she did call it rent, didn't she, the sister?
She did call it rent. However, anyway, we're overthinking it. That's the truth.
This is the magic of being
let's not go there.
But just so because it's TOLATA really that I kind of wanted to get to grips with in response to this. I mean, it does come up for me, TOLATA claims, because exactly as here, you will find an estate that holds a property where somebody else is saying, I've got a beneficial interest in that property. Even though the legal title is in the name of the deceased, I have an interest in that property, and you must not administer that property without addressing my claim. And that can hold up the administration. It can be really difficult to sort of deal with. You also get situations, where a lot of family members have had time living in a family home, but it's always remained in one person's name, or it's been moved to one of the children's, even though the parent, when doing it, expected them to share it with all the other children, but then they decide not to. So these types of claims do come up for me as well. And I suppose it's the same test, but perhaps it doesn't have quite the same sort of, I mean, there is emotion, but there's less likely to be that sort of difficulty in establishing the intent as there is with a relationship where you just potentially don't talk about these things.
But then you can imagine those families where you've got 4 children, one's always been jealous of another, and they can really think this is an opportunity for me to leg him over or whatever it is when the parents die. So I don't, it's not a competition, but I can see your clients having just as much emotion whirling around.
No, but I mean, in terms of it's more common to have an email saying, oh, Dad says it's more common to have emails around property division in family I think so. So there's actually an evidential trail.
I see what you mean.
Yeah,
yes.
Not a lack of emotion, just that there's more clarity on, at least at one stage, what was happening. Then I think that when you get into a relationship and then you just decide to move in, or you decide to invest in something, you just don't naturally have those conversations. I mean, the question was, do you encourage people to talk to each other more? But I suppose normally when you get involved in someone's relationship, it's towards the end of it anyway.
Yes, I think that's that. Yeah, too late. The horse bolted by the time we're involved. But certainly it would be a good idea. I've had a few cases, divorce cases, where you've got these big houses with 2 or 3 families and the parents all living there. It's a nightmare when it comes to, same issue really, that it's in the name of one of the children, and either you act in that divorce or you're trying, and the wife or husband is saying, well, hang on, that house is worth £10 million, so I want 5 million. And you say, no, I've got to share it with everyone else. So it does happen.
Yeah. Okay, so overall, for our listener, we think that there are avenues of claim. Stay put where you are for the moment. Take some advice and, try sort of a reasonable approach to the sister if you can. And then just before we go today, because we mentioned briefly earlier on, the legal landscape here may be changing slightly. There's been a consultation on putting into effect, I think it's a statutory scheme, is it, to give more rights to cohabitees?
Oh, yes, it's to give, it actually covers loads of different topics.
Does it?
Yeah, TOLATA is mentioned, but in sort of dovetailed with cohabitation. Then there's the idea that in divorce, we've got to have more, it's got to be more codified, because ours is very discretionary. So the idea is they're going to try and make it, if you've lived for X years, you get X percentage and so on. I don't think it's that specific at the moment. And they've asked for lawyers to comment on what they're saying. And I haven't read the whole thing yet, but I will comment. And
can we get an exclusive here then? Philippa Dola's comment on the consultation.
It'll be great, I promise you.
But
and it's because we've limped on for decades with we're the most expensive place to get divorced because judges have so much freedom, and that's a good thing in many ways. But there's been a feeling that people just spend too much money on their divorces. So if you knew roughly what you were going to get, more people would settle, which is a good idea. And then cohabitation, at last, they're talking about giving rights to cohabitees that they haven't done previously. And there's going to be loads of arguments about...
Is it because it's an opt-in or opt-out? Is it opt-in or opt-out?
I think they're saying opt-out.
Opt-out.
But it may be opt-in by Friday. You know what I mean?
Yeah, okay. Much to discuss. Great. Well, I hope that our listener or any of our listeners took something helpful from that discussion, and we will revisit the consultation and what the potential future looks like for cohabitees in these types of situations. But for now, thank you for listening and join us next time.
Bye.
Bye.